All right, so we'll go back to Anthony. So I've got a couple of teenagers in my house. They're my wife's children. They've disowned me, I think, or I've disowned them. One of those kind of things. But so if we were planning, we've got a question here around something like that, saying, let's imagine that we fast forward a bit and we're talking about wills and estates and so on, and you've got a child or a dependent or someone that you want to leave out of a will. Is there anything that would stop me from doing that? Is it possible to do so through the will, and are there any consequences of doing that?
Thanks, Matt. It's always a difficult thing to approach those circumstances. The starting point for me and for the law and for all of the court cases in that area is that in Australia we all have testamentary freedom, so we can all do whatever we want in our will. We can leave our whole family out if we want, but the consequence is that there is this act in New South Wales called the Succession Act, and within that there's a thing called the family provision legislation. And so there are categories of people who can make a claim against an estate if they haven't been adequately provided for. Sounds like a very broad and general term, and it is. The people who can make a claim against an estate are a spouse, a child, a former spouse, and that one always freaks people out, but I'll come back to it. A grandchild who is a dependent, or a person who is a member of your household and who is dependent on you. So there's a lot of categories there, and it does get pretty broad. As far as the last categories go, and I can say former spouse, if there's a former spouse, if you've had a property settlement at family law, generally speaking, you're not going to have an issue. But there have been cases where former spouses have made claims, and there was one recently where they'd been divorced for about 20 years, and the judge who she got at the first court case was very generous and gave her something. It was a very large estate, but it got overturned on appeal, and I think that was a good result because it was more reflective of I think what society expects. Grandchildren you don't see very often, and if you've got a grandchild, they're only really going to get over the additional hurdles if they've effectively been raised by the grandparent. And then that final category of people who are a member of your household and dependent on you, usually that's about, again, whether you were raised by the person and were financially dependent on them. So the one I see most commonly in that context is the stepchild, because a stepchild isn't included in the definition of a child, so they're not automatically an eligible person. But a stepchild will come in that last category as a member of the household and dependent, if they can effectively show that society would expect that they should be provided for. There's nothing you can do to stop someone from making a claim apart from, actually that's not quite right. You can, in the case of a former spouse where you have a property settlement, the property settlement in the family court is a very compelling piece of evidence for the court, and it's not often that the court overlooks that to make provision for someone. But if you wanted that family court decision to effectively be foolproof, as in absolute, that they can't come back and make a claim, you'd need to have it approved by the Supreme Court. Most people don't do that because it's almost like running a family provision case beforehand, and so it's a very expensive exercise that not many people do. And as I say, it's very rare that I even go there. So long as there's evidence of the property settlement, that's generally going to be enough. The thing about leaving a wayward child out of a will, for instance, is that it's probably one of those areas that a lot of people have a lot of difficulty with understanding the rationale behind a claim being able to be made. I often get asked, well, why should I bother having a will? And that's sometimes a fair enough case. But I guess, again, as much as the law sort of sets out these parameters, it's still in the background is, and this comes out through most of the court cases, is what does society expect? So if you've got a child, then society generally expects that you will make provision for them. If I've got situations where people don't want to leave someone who's eligible in in their will, then generally what I'll be saying to them is, well, we need to really know your reasons why, and we need to make sure that your executor is well armed to fight that case, should that person make the claim. Sometimes people will say to me, well, is it true that if you leave them $1 then they can't make a claim? It's not true. You can be left anything in a will and there can still be a claim made against the estate, and unfortunately the system sometimes means that that is used as a tool to get a better deal. Unfortunately, if you get the right lawyer who's willing to take a punt, and they're often willing to take the punt because the costs get paid by the estate, generally speaking, then you can commence your proceedings. You're going to be in a mediation within 6 months or so, and you'll generally see people negotiating settlement at that point because of the costs involved in running litigation. The system's not perfect for sure, but I guess the thing that I would say about any circumstance where there is estrangement or you don't want to leave anyone who's an eligible person in relation to your will, you really need to be speaking in detail to your solicitor about these things so that you can effectively best prepare for it and make the most informed decision. It's a very difficult conversation to have, and they are very difficult things to prepare for, but there are things you can certainly do. In the case of a wayward child, again, I go back to that discretionary trust situation. That can sometimes be useful because if you're concerned that they're going to waste it, or because they've got specific issues that means they're frivolous, or they've got drug problems or alcohol problems or gambling problems, then leaving them what they're entitled to in the will but taking the control away from them will generally work to prevent a claim being made, and it generally secures secures the benefit or the legacy that you're leaving. With any of those trusts, you will always have substitute beneficiaries, or so that when the person who you're wanting to protect passes away, you still have control over where that money's going to go, so you can ensure that it's not wasted or not lost. So as I say, it's just really an important conversation to have in detail with your legal representative.
So one of the questions